Hello there, great people, and welcome yet again to another episode of Know Your Laws, where we talk on matters to do with law, justice, and legal affairs, always to educate you and help you and learn laws that govern you. And on this week's episode, we focus on what has been happening in the country in regards to governance. We'll be talking about the composition of government with the naming of the cabinet secretaries. What is next for the government? What does the law stipulate when it comes to the formation of the government? What is good governance under the rule of law? That is our discussion this evening as we seek to give you answers as well, educate you on the laws that govern this country. Welcome. My name is Chris Sambo, and my guest for today is Levi Munyeri. He is an advocate of the High Court of Kenya. Welcome, Levi, to this particular program, Know Your Laws.
Thank you so much, Chris, for your invitation.
All right, and a broader topic it is governance and the rule of law. But let's begin here as we seek, to educate our people for the next 30 minutes. When we talk about governance and the rule of law, what exactly comes to your mind as an advocate of the High Court?
Thank you, Chris. First of all, these are not terminologies that exist in the air. Neither do they exist only in a dictionary. These are terminologies that have been enshrined in our Constitution, which actually proceeds and gives them legal meaning. The rule of law is not a new concept. The rule of law is as old as democracy and governance, dating back to even before Christ. And it's the notion that the activities of a society should be governed by the law and not by the wish of a person, in this sense, a king or an empire or a sovereign. So it is the actual introduction to constitutional law and constitutional order that the affairs of a community will not be governed by an individual person and his mind and ideas, but rather by a charter that the people have enacted as law in the name of a constitution to ensure that the society is actually governed by a set of rules that are agreed upon, can be interpreted to create a sense of order in this society. So that is the notion of the rule of law. The nexus between the rule of law and governance is that under a constitution, the people agree, we call it a social contract, the people agree to be governed by elected members of their own. Therefore, these elected members should adhere to a constitution. And the constitution under Article 10 gives a glimpse of what good governance is by enshrining what it calls national values. That good governance must be transparent, it must pursue social justice, it must be democratic, it must respect human rights, it must be accountable. So these are concepts that are enshrined in our constitution and therefore have a legal underpinning.
And when you talk about, the Constitution and enshrining what is good governance, you would say, for instance, the low class people, or rather I would say the people are at the bottom, so to say, understand governance quite differently in that if you deliver for us, if you do for us what you asked when we were electing you, then that is good governance. And then there is a way and there is a form of understanding of the urban people and what good governance is in regards to the Constitution. Those two, scenarios and the two concepts of the same people in the same country who are being governed by the same Constitution. What do you make of such an understanding?
I don't see any big difference in the understanding of these two groups of people. It is just that one group which is a little bit enlightened and learned view it in academic and constitutional terms, whereas the other one, which is not well educated and not well enlightened, view is in the context of the reality on the ground and what is expected on the ground, the practice of it. But the bottom line is that democracy being a cornerstone of good governance, then it is expected that leaders who are elected in power actually deliver to the people as per the Constitution. The promises you make on the economy and whatever premise should be delivered to the people. So what connects these two groups of people is that all of them expect delivery from their leaders as per the Constitution and constitutional provisions.
When you talk about that, someone would perhaps ask, you're talking about governance here and the rule of law. At what point does governance begin? Is it something that starts when we are in an electioneering period, or what exactly we paint a picture for what exactly and where exactly does the governance begin?
The governance is the notion of governance is quite a wide concept when you look at it from a constitutional perspective, and it does not only bind elected leaders but also the electorate and the people in general, in the sense that these are the people who actually elect leaders into office, politicians in this sense. So governance are principles that are expected to be performed and to be adhered to in an ideal society. And when you look at it from a constitutional perspective, if you check something like, democracy, democratic principles as a form of governance, good governance, this is a notion that is not only expected among the elected leaders, but the people themselves, in the sense that during an election, the people are expected to go and effect this democracy by voting. Failure to vote is actually in an adherence to this provision. It now touches most on people who are elected in office, from an MCA to a governor to the president, that these people are going to exercise their powers as per the constitutional values that are enshrined. In this sense, whether you are an MP, you are performing your legislative role, you're expected to perform it in a manner that is transparent. You're expected to perform it in a manner that pursues social justice. You're expected to perform it in a manner that is accountable. And accountability is a very blanket concept, constitutional concept of good governance, in that every leader has to become accountable to the people. How do you become accountable to the people? You should, from time to time, go back to the people and tell them what you are doing. What have you done? That is something that lacks in Kenya. You know of countries where a president at the end of every 2 months, you don't need to wait for a State of the Union, you give an address telling people what have you been doing, to account to the people. For those 2 months I've enacted these laws, for those 2 months I've done this, I've visited these countries, I've solved this and this problem. So it is, when you talk about governance in the context of our constitution and constitutional values that are enshrined under Article 10, essentially you are talking about values that should be pumped in every function of an elected leader. Whether you are performing legislative function, whether you are performing presidential function, you should perform it within the context of accountability, transparency, democracy, and the rest.
Talking about these particular positions, all of them under the governance, they are as a result of the biggest democratic milestone, that is the inception of the 2010 Constitution. Looking at the decentralization of the national government into the 47 counties, thus allowing a wider representation of the Kenyan people in regards to governance. What do you make of the decentralization of the Kenyan government, in vis-a-vis adherence to the rule of law in regards to the 2010 Constitution?
Chris, it's no accident that Article 1 of the Constitution, the very first article of our Constitution, talks about sovereign power of the people, and clearly states that sovereign power belongs to the people. And immediately after that, it goes to state how this sovereign power will be exercised. It introduces the 3 branches of government, that is the executive, the judiciary, and the legislature. And then down there introduces the 2 levels of government, that is the national government and the county government. So the people, through their sovereign power to elect their leaders, would therefore exercise their powers within these 5 branches and levels of government. Devolution, if you look at it, is actually the greatest invention of our Constitution. Initially, it was treated with a lot of suspicion, but it has come to perform very well over expectations. And the purpose of devolution is simple, that people are spread across the country in various corners. There is no way all these people are expected to exercise their sovereign power, to state how they should be governed to the president through Nairobi. Let this power go closer to them. And that is the invention of county governments, that people will have power closer to them. If you look at the import and structure of the constitution, a governor would be said to be a mini president, that a gentleman in Turkana will have an equivalent of a president who understands him better and understands the problems of Turkana better, stationed at Lodwar rather than in Nairobi. This person is accessible. This person can be more accountable to the people. This person understands the dynamics of that area well. So as the president, I remember used the word during his inauguration, the judiciary and devolution are the greatest dividends of the 2010 constitution. They have brought power close to the people. They have brought development close to the people. They have brought good governance close to the people. They have brought accountability in political leadership close to the people.
And in the view of the inception of the 2010 constitution and also the different levels of government, there has been performance by both the national government and the county government. What would you make, or what would you say the two levels of government have done in regards to adhering to what the 2010 constitution stipulates?
The beginnings were rocky. When the constitution was enacted in 2010, the first set of elected leadership came after the 2013 constitution. And just like the introduction of any constitution to any jurisdiction, at the very beginning you suffer serious problems in the context of interpretation of that constitution to know what are the roles of a county government vis-a-vis the roles of a national government. And our country being a developing democracy, and the whole scourge of leadership wrangles and scramble for power, you could see some collision between the national and county government, starting with revenue allocation. How much do you allocate to counties? When do you allocate it? And who should be accountable for it? So it was expected, and from 2013 now we are going to the third set of parliament and elected leaders in the new constitution, 2010, not very new. And we are seeing steady but progressive development and accruing of the benefits of devolution. 2017 we elected new leaders. They came in a different regime of governors, some re-elected, some not. And we could see some more efficiency, more good governance in interpretation of the laws. Some of them went to court, and the court could clearly demarcate what is the function of a county government and what is the function of a national government. They serve one function, to serve people, but where do they draw the line? Where do they work together as different levels of government? There are some aspects like agriculture. There was a contention on whether agriculture is a devolved function or a national function. But the performance keeps steadily growing. We are not yet there, but we'll keep going to that direction if we adhere to the constitutional provision. One of the hallmarks is that anytime there is a dispute, parties have embarked on the dispute resolution mechanism under the judiciary, where they would seek interpretation of the law on what the dispute is. Most important, the people have also come to appreciate those functions. It's very important. If it's a question of a quarry in Kakamega town, those people know that the person to ask about this quarry and stones is not their MP, neither is it the senator. Is to ask an MCA and the governor, being the ones who are given that function. If it's something about agriculture, the same thing. If it is something about security, they know that it's the national government that deals with it. So we are not yet there, but we've made substantial strides. That is commendable, and let's keep supporting devolution. Let's keep implementing it. It's not fully implemented, unfortunately. And with that spirit, we are going to enjoy its benefit to the fullest.
Right, and talking about implementation of the devolution lies under the three arms of the government, that is the judiciary, the legislature, and the executive. from the three arms of the government, we talked about the national government and the county government, their adherence to the rule of law in terms of governance. For the three arms of government, how have they incepted the 2010 constitution, as well as incepted the rule of law for them to deliver good governance?
When you talk about the three arms of government, we go back to a doctrine under constitutional law called separation of powers, that power should be exercised separately within the branches of government. And the whole notion, just like the rule of law, is to avoid over concentration of power within a single person, which makes it prone to abuse. So separation of power again comes back to Article 1 of the Constitution. Sovereignty belongs to the people. And if you analyze the Constitution, you'll see the three arms of government, that is chapter 8, 9, and 10. The first sentence is that the judiciary, the legislature, and the executive are exercising their powers as delegated by the people. So those powers are delegated by the people. There is an argument on which one is actually more powerful than another. Under the law, they're expected to be equal to each other, but their functionality is what differentiates them. When you talk about the executive, you are talking about the presidency. That is the office of the president, the cabinet, and the whole structure up to down. And the same applies to the governor and his cabinet at county level and its structure that it sets. When you talk about the legislature, we're talking about that is parliament. Parliament at national level is bicameral. There is the National Assembly and there's the Senate. At county level, you also have the county assemblies. So you can see one distinction, that as the executive and the legislature are concerned, it is properly devolved. However, on the judiciary, we're talking about the courts. The courts remain under the Supreme Court, and there are no county courts. Although devolution in the context of courts is ensuring that courts go to the ground, and the judiciary has performed that very well to ensure that courts are demarcated almost close to any village in Kenya. It is work in progress, but it's progressing well. The biggest stumbling block to the functionality of the three branches of government has been the executive. And it's not by accident. The executive comes from a pre-2010 state where the president was all powerful and could try to pull the strings in the judiciary and the legislature. And that hangover is still there up to today. The greatest performer in post-2010 when it comes to functionality of the three branches is no doubt the judiciary. The judiciary has been very progressive, and you can strikingly note that performance, which is stellar, is because of the leadership. Immediately, the 2010 Constitution was enacted. The first Chief Justice was Willy Mutunga. From Willy Mutunga, we went to Maraga, and now we are having Honorable Justice Martha Koome. All of them have performed very well. Martha Koome is still performing. And a judiciary becomes very important because it is the ultimate interpreter of the law. The judiciary, there are numerous cases in court where the judiciary has actually stopped the president in his tracks, telling the president, this order that you've given is illegal because it does not have a constitutional basis. The same would apply to parliament. Parliament would enact a law that is draconian or a law that is unconstitutional, and someone would rush to court. A president can, I remember one of the issues was a president directive that was under former President Uhuru Kenyatta to increase the prices of fuel. And someone rushed to the High Court of Bungoma, a gentleman who probably has never even been to Nairobi, and he stopped those orders temporarily before public participation is performed. So that's the beauty of our constitution. It's emerging actually as the finest in the world because in terms of provision, it is very thorough. Another very problematic misconstruction among Kenyans and even in court is the notion that these three branches of government are distinctly separate. That's not the position. The Constitution anticipates that these branches of government will work together to perform the common goal of, serving the people and ensuring that sovereignty belongs to the people. However, they should retain their distinction in the course of that performance.
And talking about the relationship between the executive, judiciary, and legislature, you talked about the interdependence between the three arms of government. How dangerous would it be to governance in where the executive supersedes its jurisdiction and say, for a lack of better word, say disobey the judiciary, or rather the other arm of the government, the legislature?
The consequences definitely are catastrophic in the sense that the rule of law, which is the first thing we discuss, collapses. The rule of law, the custodian of the rule of law is the judiciary. The judiciary, as the interpreter of the Constitution and other laws, decides what is the law. So in an ideal case, which for the last 10 years we've made tremendous strides, is that the president first feels he has an obligation to respect the Constitution, and second, it's becoming clear that he knows he has no choice, because even whoever you will direct, if you give someone an appointment outside the Constitution, and someone goes to court and challenges that appointment, it has happened with the current Busia Senator Okiya Omtatah, has gone to court on numerous occasions to challenge appointment of the president. The president, in one or two cases, Uhuru Kenyatta, when he defied the same, you find even the person who has been appointed feels he has an obligation to comply with the court of order. So he'll definitely resign or simply ignore that appointment. So we are going to that level where not only the president but institutions actually feel an obligation, and that's a governance issue, that if you are a governor, you've enacted a law, and the court gives orders to the contrary, you feel you have an obligation to comply with those court orders. The challenge has been the relationship between the executive and the legislature. The judiciary has come out clearly to perform its functions. The problem has arisen between the judiciary and the legislature and the executive, in the sense that the legislature should also be independent from the executive in terms of enactment of laws, which is its core function. But you find a lot of interference, because MPs would take instructions from the president directly, and they'll actually fail to perform the oversight role because of partisan affiliations. Instead of focusing on performing your role, it is now a partisan issue, whether you're in government or opposition. And at the end of it, they become rubber stampers of the president. That thing has to be looked at thoroughly. The last parliament was a total failure in that. They could not stand and tell the executive, no, we have a role, it's a constitutional role, let's perform it. You cannot be pulling the strings on what to do. So that has to be worked upon. It's equally important as the independence of the judiciary, that people can make laws without affiliations and instructions from the executive.
At the core of all that would say is also the good conduct of the executive, and also the composition of government. And looking at this, in the case of the executive, leading in terms of governance is also the appointments. You talked about the president being able to appoint someone, and then the judiciary says that this person is not appointed in the basis of the Constitution. Let's talk about the powers, or rather the abilities of the executive. Say, for instance, in the appointment of the cabinet secretaries, what powers does the executive have?
The provisions on appointment and the functions of the cabinet are actually stated in the Constitution under Article 152. And one of the things I was keen to note at this juncture is the numbers. The Constitution, in its wisdom, stated that cabinet secretaries shall not be less than 14 and not more than 22. So it limited the number, and the mischief was, especially under the Moise regime, because of patronage and the feeling by a president that he needs to reward everyone who assisted him or her in winning an election. I saw the case in Uganda when Museveni won the elections for this term. He ended up electing one of the largest cabinets in the world, of more than 60 people. So the parliament, the architects of the constitution had to limit this number to ensure that it's a number that is reasonable. Cabinet is a very, I'll say, intimate body to the president, because cabinet are people who perform the agenda of the president. That's why they're under one branch of the government. All of them belong to the executive. And Kenya has very robust employment laws. I remember one of the cases that I handled was a question on whether there is a procedure for a president to appoint or, fire, terminate a cabinet secretary. And the Judiciary was very clear. Because of the intimate role, these are people who execute the function of the president and pursue a presidential agenda. The president is actually at will to terminate their contract anytime and fire them, because a president is expected to take a cabinet that believe in him. If you don't take people that believe in your agenda, if saboteurs creep or into the cabinet, then you are done. Your agenda will totally fail. That is one. Let's come back to the appointment. A constitutional safeguard that the architects of the constitution considered rightly is to ensure that a cabinet secretary is vetted by the legislature. That's the National Assembly. And it comes back to what we are talking about, separation of power. One of the major functions of the National Assembly is oversight. Oversight means whatever the executive, the president does, then you are able to check it. And that's why the president has the sole duty. He can wake up at night and declare a cabinet, but that cabinet is subject to approval by parliament. And it's something that I'm very keen to see, because those cabinet members, some of them have had their own share of scandals, issues of integrity. Can our legislature, can our National Assembly conduct proper vetting of those gentlemen? It must be public. The vetting must be thorough. Members of the public should be allowed to do their input, some form of public participation, so that everything hidden, open concerning these appointees is brought to the fore, and Kenyans are able to understand them properly. And hopefully the president will not pull the strings again so that parliament has to play to its tune. Let the parliamentarians do their job, and there's a test of ascertaining whether this vetting is successful. Will even one or two of these appointees be rejected by parliament? If one or two are rejected, that means the vetting process has been proper. If you find all of them are hastily, passed, then it points serious doubts on whether that vetting process has been efficient.
And talking about vetting and also the appointment of cabinet, just quickly as we conclude this discussion, let's touch on the appointment of a chief cabinet secretary. You talked about the number being 22, but all the same is part of the 22, but now given the mandate of the chief cabinet secretary. Does that have any implication in what the law stipulates when it comes to, the appointing of the cabinet secretaries?
Good that you've asked that question, and it comes back to what you've been talking about, governance and the inclination and willfulness of our leaders, starting from the president, to adhere to the constitution. The constitution talks about 14 to 22 cabinet secretaries. Definitely does not contemplate a chief cabinet secretary. There is no such position. What the president does, which is a legal maneuver that ensures that the whole appointment is not unconstitutional, is that he has been enshrined among the 22, so it has not gone to 23. So he can argue successfully constitutionally in a court or anywhere else that this is just a name. It is a tag that has been given to this cabinet secretary, who should ideally be a normal cabinet secretary. It's an administrative name, but you read mischief in that. It is a creation that actually borders what you'd call a prime minister. You are trying to raise one member of the cabinet for political or administrative reasons to be superior to others. If the constitution wanted some cabinet members to be superior to others, then it would clearly say so. So it comes to a question of accountability, a question of transparency, and the national values that we've been talking about. Someone might try to challenge it in court. It should not pass. Where I want proper accountability on who this person is, it's during the vetting. Parliamentarians should come out clearly and ask, what is this chief cabinet secretary position? What is its portfolio? I had the president trying to enumerate what he's supposed to do, but cabinet secretary should handle dockets. What exactly is his docket? Is he overseeing the rest of the cabinet? It should not be. The president should be the one overseeing the cabinet. So it points towards a start where a president is willing to circumvent some constitutional provisions in a manner that does not adhere to constitutional governance.
All right, and I think it's quite a watch and see on whether what comes out of the legal battle, if at all there will be one, in regards to that position of the chief cabinet secretary. A very big question that you raise about what portfolio do you hold in the cabinet? And I think we'll also be finding time to also talk about the three arms of government, the functions of the executive, legislature, and also the judiciary, as you also seek to educate our viewers in regards to good governance and adherence to the rule of law, which is very critical for our country's daily running. Thank you so much, Levi Munyeri, for making time for this particular episode so that we get to educate and give our viewers a taste of what good governance is. Thank you so much.
Thank you so much, Chris. Such a program is definitely very important for the consumption of the public.
All right, and that is where we wind up this particular episode of Know Your Laws. We've been talking about governance and the rule of law, touching out on the issues that have come out in the recent past in regards to what next for the government in the composition of its members. That is what we've been talking about, and we'll also be talking about the legislature, executive, and judiciary in our subsequent episodes, as we seek to also give you a good understanding on the Kenyan government. And that is where we wind up. My name is Chris Sambo, and this has been Know Your Laws. Goodbye, and see you on the next week episode on Thursday at exactly 7:30 p.m. Goodbye for now.